Welcome to UNH Law School's faculty video lecture series. In this installment, my name is Behzad Mirhashem, and I run the criminal practice clinic, and I also teach evidence and criminal procedure. And I'll be talking to you for about 20 minutes at an introductory level about the question of how you apply the Constitution's search and seizure protections to some new investigation technologies that have been made possible that were really not contemplated at the time that the Constitution was adopted. So to help make our discussion concrete, here are a few questions that you can think about. Say the police suspect me of growing marijuana in my house, but they don't really have enough information to go to a judge and get a warrant. But they know that growing marijuana requires putting up some strong lights, and these lights generate heat. And so can they set up some sort of a heat sensing infrared detection device outside of my house and look at the heat flow patterns in the walls and windows, and from that try to develop evidence of the kind that they can then present to a judge to go ahead and get a warrant? Or say the police suspect me of being a drug dealer. Can they attach a GPS device to my car and try to track my movements as I may drive to, say, my supplier's house? Can they put a GPS device on there and track my movements for months? Say the police suspect me of being involved in, say, a bunch of robberies that happened over various dates over several months. Can they go to my cell phone company and obtain data on the different cell towers to which my cell phone connected over that time period to try to recover information about my movements during that period, which they can use to establish my involvement in these robberies? All of these questions involve the limitations on the power of government to essentially, in one way or another, intrude on my privacy. And there are various sources for limitations on this power of the government. The limitation that I'm going to focus on today is any limitation that may be placed on these investigation techniques by the Constitution of the United States. And specifically, I'm going to focus on the primary constitutional provision at issue in such cases, and that's the Fourth Amendment. Now, the Fourth Amendment, if you took a course like criminal procedure, we spend most of the semester trying to understand various aspects of the Fourth Amendment. And here in our short lecture today, I'm just going to focus on one aspect of it. So if we take a look, if you could put up the slide that contains a portion of the Fourth Amendment in it, and you see that the Fourth Amendment says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So the question that we have to think about is, when the police attach this GPS device, or when the police obtain the cell tower data, or when the police look at the pattern of heat flow coming out of a house using an infrared detection device, are they engaging in an unreasonable search or seizure? And in a course like criminal procedure, you would learn that what's really at issue here is not a seizure. A seizure is like grabbing somebody who's walking down the street or grabbing something that belongs to them. We're really more concerned here with searches. And you learn in a course like that searches often, but not always, are considered unreasonable if they're conducted without a warrant. And we're not going to focus on that aspect of it. We're going to focus on, was there a search at all? does a search under the Fourth Amendment occur when the police set up this infrared detector device and pointed at my house? Does a search under the Fourth Amendment occur when they obtain the cell tower data on my telephone? Now, the Fourth Amendment was adopted in 1791 when there were no cell towers, there were no GPS devices, there were no infrared detection devices. And back then, it's pretty clear what was probably meant by a search. You know, the police search my house when they enter it and start looking through my closet or looking through my drawers. Everybody understands that that's what a search means. And so the problem becomes, as society has changed, does that meaning of the word search remain fixed, or does that meaning change in time? Now, to really understand this issue, we have to pay a little bit of attention to a couple of aspects of how the Fourth Amendment is actually interpreted. One is to recognize that the U.S. Supreme Court and the lower courts are not in the business of making abstract pronouncements about the meaning of the Constitution. They don't take the text of the Fourth Amendment and write about what it could mean in all different sorts of contexts. Instead, courts decide concrete cases. So in a concrete case, somebody, may have evidence in a criminal case developed against them because the police obtained the cell tower data, and he is put on trial. That evidence the police want to use against them at trial, the prosecution wants to do that. He claims that violates his rights. He seeks to suppress that evidence. The judge denies the motion to suppress. He gets convicted. He appeals. Ultimately, a very small fraction of the cases go up to the U.S. Supreme Court, and the court, in the context of a concrete case, decides this Fourth Amendment issue. The other complication that we face here is that there is no uniform view on the court of what style of constitutional interpretation is the right one. Some justices are so-called originalists. They say that what this text means, what unreasonable search and seizure means, is what the framers of the Fourth Amendment meant in 1791. Some of those originalists tend to be so-called textualists. They say, just look at the words, look at a dictionary from back then, and the common understanding of the meaning of those words is what you should really focus on. Other justices are of the view that, these broad words in the Constitution were not meant to be frozen in time, and they have to be interpreted in light of more recent developments in society, including technological developments. So what I'm going to do now for the next several minutes is talk to you about some of the key cases that have come up to the Supreme Court dealing with technologies that were not contemplated by the framers of the Constitution, and explain to you how the court handled this issue in those cases. The first case that we should talk about in this context is a case called Olmstead versus the United States. This was a case from 1928, not so recent, but sufficiently after 1791, where you did have new technologies. And specifically, the technology in that case was that Mr. Olmstead was suspected of some wrongdoing, so the police attached some wires to the telephone lines entering his house, but the wires connected to the telephone lines outside of his house. So it wasn't his property that the police were probing. And so they listened to the conversations, obtained incriminating evidence against him, and he was convicted, and he appealed to the Supreme Court, claiming that his Fourth Amendment rights were violated. The Supreme Court held in the Olmstead case that wiretapping was not a search. If we take a look at the slide again, you'll see that the slide says that the Fourth Amendment guarantees the right of the people to be secure in their persons, houses, papers, and effects. The court focused on those categories and said that what these categories share is that they're all material things. Your person, your house, your papers, your effects, meaning your belongings. So the protections of the Fourth Amendment are limited to material things. And capturing your conversation in a way that doesn't impinge on any of your material possessions is not a search. In response to this claim that it's only material things that the Fourth Amendment is concerned about, there was a famous dissenting opinion in the Olmstead case by Justice Brandeis. And I think it's worth reading several sentences from his opinion because they turned out to be prescient. He said, the makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of man's spiritual nature, of his feelings, and of his intellect. They knew that only a part of the pain, pleasure, and satisfactions of life are to be found in material things. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. They conferred as against the government the right to be let alone, the most comprehensive of rights and the right most valued by civilized men. To protect that right, every unjustifiable intrusion by the government upon the privacy of the individual, whatever the means employed, must be deemed a violation of the Fourth Amendment. So Justice Brandeis was saying searches are about more than material things. They're about unjustifiable intrusions by the government upon the privacy of the individual. And these words, even though they did not have the agreement of a majority of justices in 1928, later turned out to be very significant. Because about 40 years later, the Katz case came up to the Supreme Court, and that was a case that was essentially similar to Olmstead. Somebody was in a phone booth. You may be too young to remember phone booths. And what the police did is they connected a device to the outside of the phone booth to listen to his conversation. Again, the argument was there's been no search. Olmstead said we focus on material things. And here, listening to the conversation by attaching this device to the outside of the telephone booth doesn't qualify. This time, the Supreme Court rejected that argument. And the majority opinion said the Fourth Amendment protects people, not places. What a person knowingly exposes to the public, even in his own home or office, is not a subject of Fourth Amendment protection. But what he seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. Now, when the Supreme Court decides cases, you always have a majority opinion that may be unanimous, but sometimes you have dissenting and concurring opinions. In this case, there was a very important concurring opinion by Justice Harlan. He formulated a test that said that there's a Fourth Amendment violation when there is an intrusion upon a reasonable expectation of privacy that an individual has. And this reasonable expectation of privacy, and he actually said it has to be both reasonable and you actually have to have it, but the focus primarily has been on its reasonableness, has become the test for whether a Fourth Amendment search has occurred. So the police attach a wire to the phone lines coming into my house. Yes, I reasonably expect the content of my calls to be private, and Therefore, I get protection under the Fourth Amendment, even though there was no physical search. Now, this concept, though, was significantly limited in a case called Maryland versus Smith, where the police went to the phone company and obtained from the phone company, using a device called a pen tracer, all the phone numbers that an individual had called. And in that case, the court said, look, you call numbers, you know the phone company knows what numbers you call. You assume the risk that they're going to share them with the police. It's not like the content of your call where you took steps to keep it private. The numbers you call are in private. So this is the background against which the Supreme Court has struggled to reconcile a textual understanding of the Fourth Amendment against a more modern, reasonable expectation of privacy analysis. And I'm going to conclude by looking at two very recent cases dealing with this issue. One from a few years ago is the Jones case, where in fact what the police did was attached a GPS device to a car and used it to monitor the movement of the car for almost a month. And the Supreme Court in that case was sharply divided on how to analyze the problem. Interestingly enough, all 9 justices agreed that tracking every movement of someone's car for a month should be a search under the Fourth Amendment. Some of the justices, though, focused on a historical trespass understanding of a search. They focused on how this device was attached to the car, which was someone's property. So under a traditional understanding of the Fourth Amendment, there was a search. Other justices said, no, you should use this modern, reasonable expectation of privacy test. The ones who used the historical test were saying this modern understanding never substituted for the historical test. It was supposed to be added to it. Now, this uncertainty in the interpretation of the amendment continues to this day. In a few days or weeks, the Supreme Court is going to issue its opinion in the Carpenter case. Mr. Carpenter received more than 100 years in prison in a robbery prosecution where the police used historical tower data to establish that he was in various locations where robberies had been committed. And what's really interesting in that case is that it is has caused the court to go back and re-examine that pen register information that I told you. As I said, the court several decades ago said, hey, you expose the numbers that you call to the phone company, you don't have an expectation of privacy in that anymore. You assume the risk that this information may be disclosed. Now, with the development of technology, the court is facing the situation where, just like GPS, the cell phone towers that your phone connects to when you send or when you make or receive telephone calls is a detailed set of data about everywhere you've been over an extended period of time. And is that really not protected at all by the Fourth Amendment because you assume the risk that the information would be shared with the police? Is that really an accurate understanding of how we use our cell phones, given the realities of how integral they are to our lives? Can it be said that we've decided to share this information with the phone company and we have knowingly taken the risk that it's going to be shared with others? The court's going to decide this case in a few weeks or maybe even days. And when the decision comes out, it's likely to reflect the continuing divisions on the court about to what extent to be faithful to a textual, historical understanding of the Fourth Amendment and to what extent to look at it as a living and evolving document. So thank you for listening to this lecture, and I encourage you to visit our website at law.unh.edu for further information about our law school.